Good evening, everyone. Good evening, everyone. My name is Srishti Sharma.
Good evening, everyone. My name is Srishti Sharma, and I am a student of LLM 1 year batch, and I'm doing mediation specialization. And on behalf of organizing committee, I extend a warm welcome to all participants joining us for the second session of our online guest lecture series. Today's session focuses on a very significant and timely theme: role of judges and lawyers in strengthening mediation culture in India. It is indeed an honor to have with us Mr. Vinay Kumar Khanna, sir, a master trainer since 2009 under the aegis of Mediation and Conciliation Project Committee of the Honorable Supreme Court and a distinguished judicial luminary. Allow me to briefly introduce our esteemed speaker. Shri Vinay Kumar Khanna sir completed his LLB from the Campus Law Center, University of Delhi in 1988, and after graduating in Physics Honours from Hansraj College, he later earned his LLM from Kurukshetra University in 2001. He joined the Delhi Judicial Services in 1992 and was promoted to the Delhi Higher Judicial Services in 2006. Over his institutional illustrious career spanning more than 32 years, he has served in various capacities as civil judge, metropolitan magistrate, additional session judge, special judge NDPS, presiding officer labor court, family court judge, and a district judge commercial court. He has also held the prestigious position of principal district and session judge, North District Rohini, as a trainer mediator since 2007 and a master trainer since 2009 under the aegis of Mediation and Conciliation Project Committee of the Honorable Supreme Court. Mr. Khanna has imparted mediation training to judges, lawyers, and students across India. During his tenure as judge in charge of the Saket Mediation Center, he facilitated the settlement of over 1,100 disputes. Even after stepping down from office on 31st Jan 2025, he continues to contribute actively as Senior Master Mediator for MCPC, conducting training programs for Supreme Court Mediation Center. He also empaneled as a mediator at the Supreme Court Mediation Center. In today's lecture, Sir will share his insights on how the judiciary and legal fraternity plays a pivotal role in cultivating and strengthening a culture of mediation in India, a theme that aligns closely with the objectives of the Mediation Act 2023 and a broader area framework. Without further ado, I will now invite Mr. Vinay Kumar Khanna, sir, to address the gathering and enlighten us with his valuable thoughts and experiences. Sir, please.
Thank you. Thank you. I'm really honored, feeling privileged to have been asked to address the audience at the university. And I think we must be the change we want to see in the world. I think I will feel connected if all the participants also put on their video also. I think I feel more connected. Uh, I think India, our population is 150 crore, around 5 crore cases are there. And the question is now, the topic is role of judges and advocates in strengthening mediation in India. So the question is, first we have to know what is mediation and why should we strengthen it? And then the role of judges and the role of the lawyers in this. Uh, our is a vast country. We know, as I said, 150 crore people, a growing society, disputes, you see, disagreement and disputes are bound to be there when the society, plural society we have, and the disagreement and disputes must be there in every society. So when disputes are there, so dispute resolution mechanism has to be there. We have the traditional litigation method, and then you see this ADR has come. So the mediation, which was seen as a alternative dispute redressal in the beginning, it became then additional, and now it is said it is appropriate dispute redressal mechanism. And it is not that only because the cases, there were pendency of the cases, backlog of the cases, that was one factor. But because speedy dispute resolution, then it becomes very important. And also, we were seeing that ease of doing business globally, we were lagging behind. That was one reason. And creation of this conducive environment in society, we want law and order, peace and harmony. We know maintaining peace and harmony is the aim of the justice we have. And we are always talk about access to justice. Then our preamble talks about socio-economic political justice. So it was seen that delays were there. And if I give you data that in the last year, between April 2024 to March 2025, about 6,792 judicial officer mediators, 11,861 lawyer mediator, and 2,264 other mediators who have performed their role and in assisting settlement of 98,406 cases. This is, I am telling you, as per the NALSA, National Legal Service Authority's data website, statistics, information. So we see that mediation now, it is the flagship of the ADR. And we see the future is very bright and very promising. But again, as we say, why we should choose mediation? What is mediation? So first of all, we must understand why it should become a culture, or why we should strengthen the culture of mediation. And we know that it started after 129th report of the Law Commission, Section 89 was inserted into the Civil Procedure Code. Then it was found there were certain, this was as regards the ADR. ADR, that the civil courts where the cases are pending, they must choose one of the ADR mechanism. Could be arbitration, mediation, judicial settlement, conciliation. But it is now found that mediation it has become immensely popular and it is more satisfying. There is a win-win situation. Because of its win-win situation. Now, what is mediation? Mediation, a mediator, what mediator does? Mediator assists two disputing parties to arrive at a mutually acceptable solution themselves. So we say there is a self-determination. Party determine their case themselves. It is a mutually acceptable solution. Then neutrality is there. Mediator would be neutral like a judge, but he will not be judge, he will not decide. Then confidentiality is the heart and soul of the mediation, which says whatever transpires in the mediation is confidential. That is one of the beauty of the mediation. In court, otherwise whatever happens is open. So in the open court, but in whatever transpires in mediation, whatever party discussed with the mediator has to remain confidential at two levels. It will not be shared with the other party without his consent. It will not be shared with the court. Court cannot ask. Rule prohibit that. So I'm firstly giving you what is mediation and the benefits. We know it is a flexible process. It is not like court, that in court you see we have adversarial method. There's a claim, there's a defense, the issues are framed, evidence is led, cross-examination, then a innumerable application are filed, then court hears argument, then decide, then there appeal. That is a traditional method we have. But here it is a flexible method. We say mediation is a structured process. Why? Because it is a scientific process. It has stages. What are those? Parties, whenever mediator becomes part of the dynamics of the conflict, first of all, he will introduce himself, take introduction of the parties. He will tell them the ground rules. I'm telling you the background so that when we come to the roles, we have the basic idea for some of those who may not be aware of that. Then thereafter, in the joint session, he will understand, gather the information, the fact, what is the dispute. Then there will be separate sessions, caucus, which we say in caucus, he or she can hear separately with the party, with or without counsel. Then there is a sub caucus, we say, where mediator can hear separately with the parties or separately with the councils. Then he can just have a shuttle again, go to the joint session, again come back to the single session, caucus, and then once parties settle, then settlement is recorded. If it is not settled, then we'll send a non-stop report. So as we said, there are two models. So far, we had court annexed mediation, and now after this Mediation Act 2023, we will have other ad hoc private mediation also. So there we will have mediation service providers, the Mediation Council of India. They will be registered with the Mediation Council of India, and then the mediator will, the party settle would record mediated settlement agreement, which then would be enforceable like a decree and award. Of course, that can be challenged if there's a fraud, corruption, etc. The grounds as mentioned therein. So this is now a little background. Now, Section 89, we saw Section 89, then came to the picture in 2002. Briefly, I'll give tell you about a few cases. Salem Bar Association case then, 2002, it found that there were certain creases which had to be ironed out, that the judge had to reformulate the terms of settlement. It was held that it is not necessary. Only he has to be satisfied that there are elements of settlement. Then you see in the year 2010, AFCON's judgment, which you must read, and that which gives in detail all those things what should have been done, could be done. And then we see then in the 2021 case, Krishna Murthy versus New India Assurance Company Limited case came, a case for motor accident claim tribunal, where court said that government should explore enacting a Mediation Act to provide the procedure for mediation and changes in Motor Vehicle Act to create, and also to create one motor accident mediation authority. And it emphasized the importance of ADR mechanism in promptly settling the dispute. So we see this mediation makes access to justice easier. It is a transformative approach to the justice delivery. So it is different than the traditionally, because we saw initially there was some reluctance on the part of councils, stakeholders, having that traditionalist approach, who were skeptic about this process. But now, and because they were apprehensive that if this happens, suppose the case is settled in the one go, then what will happen to their fees of the council, etc. And but now it has been found that these apprehensions are misplaced actually. And then to begin with, I tell you, we have in mediation, we say thinking out of box, lateral thinking. Because why it is done, how it is done. In the cases, only it is in right based, right duty. These are my claims, defenses. But here in mediation, mediator will understand the interests of the party, underlying interests of the parties. And then once he understand, one party understand the interest, then they generate options, and then they find mutually acceptable solution, which is more satisfying. I have seen in my experience, I have been judge for 32 years, and then now I'm acting as a corporate and a senior counsel also. I've been mediator also. But I've seen that whenever I assisted settling a case, instead of deciding a case, it was more satisfying for me. And if I, in this context, we often hear, and which I read it out to you. But Mahatma Gandhi had said for the lawyers, he said, I had learned the true practice of law. I have learned to find out the better side of human nature and to enter man's heart. I realized that the true function of a lawyer was to unite parties driven asunder. The lesson was so indelibly burnt into me that a large part of my time during the 20 years of my practice as a lawyer was occupied in bringing about private compromises of hundreds of cases. I lost nothing thereby, not even money, certainly not my soul. So this is what Mahatma Gandhi said about hundreds years ago. And and this is what I say I also felt during my experience practically. So uh, so as I said that when we have this tool, this mechanism, it is now becoming a culture because it furthers access to justice. It furthers our constitutional value of bringing socio-economic justice, fraternity, and the rule of law. And you see, faith of the people. And one more thing I'll say, when we say that cases are there, of course, cases, huge pendency is there. But that huge pendency or delay, that doesn't mean that traditional system was not working. It is working perfectly. But because of the faith of the people, trust of the people, more cases are coming. As society is growing, more cases are coming to the legal system. That is why cases are more. Of course, the litigant ratio is are not that proportionate. That is one reason of the delay and the speed. But since in every walk of life we are expecting speed and speedy justice is a we know Article 21 speedy justice we know. So similar expectation was there. So this mediation, we have found that has shown that this is the way that when we have this settle the mediation with the settle the case with the system of mediation, we have that speedy resolution of dispute. In we have seen in that COVID-19 pandemic time that we used to hold the court through video conferencing. And otherwise, you see, there were a lot of people found, lot of pressure, lot of tension because people were not complying with their contractual obligation. A lot of cases were coming. But with the use of that technology, online mediation were held. And so it proved to be mediation proved people found that this is a mechanism, this is a tool which is quite satisfying and would serve them the way they want. Uh, so momentum is being built up. It is a process, I said, is a flexible, provides them opportunity to settle all these cases. If I tell you briefly about other cases where we Section 89 I mentioned, Section 12A Commercial Court Act 2015, we have which says pre-institution mediation. Now we are talking about earlier we were talking about court-next mediation, where referral judge would refer the case to the mediation, mediation center attached with the court, and mediator which were empaneled, they would they would assist the parties and assist settling the case. Case will go back to the court. Then, if it is settled, court would, after satisfying, pass a decree. and the matter would be disposed of or would be executed. But now we are moving towards pre-interest mediation, pre-litigation mediation. Section 12A of the Commercial Court Act has shown a way. Similarly, we have several other provisions we see. We have in Companies Act now, Section 442. We have this MSME Development Act 2006. Consumer Protection Act 2019 is there. So, and now there is a Mediation Conciliation Project Committee of Supreme Court which had come into being after the Salem Association case, which is overseeing all this mediation in India and has been instrumental in making this, in strengthening the culture of mediation in India. And we see that now, of course, there are certain areas where it can't be invoked. If we can see the Schedule 1 of the Mediation Act 2023, or we can see re-DEFCON judgment, where it mentioned in certain cases uh, where it can't be invoked. For example, forgery, fraud, serious fraud cases, or serious criminal cases, cases involving public policy, etc. Of course, there can't be involved. Now in trade, commerce, contract cases, construction dispute, corporates, torture liability, matrimonial, we have found they are very effective in efficacious disposal of the cases. They have become, now we see a strong and effective ADR mechanism. Culture is now coming in the way, and we have to, as a law student, all of you have to grab this opportunity, because now coming time would be of mediation. You take my word, in few years from now, and also Singapore Convention on Mediation, we are a signatory. Of course, we have yet to ratify that. Uh, what is the impact? Impact is reducing burden on the court and satisfaction of the people. It is a win-win. And one more thing, it restores the relationship. But a restorative justice, we talk about restorative justice. And relationship is restored when both parties are satisfied, they shake hand, not like a traditional method where one wins and the one loses. Then the relationship is rebuilt. That old relationship is restored. That is one other duty. But now we have to see that it casts now. When we talk about the role of lawyers, role of the judges, an obligation, a duty is cast upon the lawyers and the judges to strengthen it. They have to be careful while ADR, what type of, like in the old method, as a reference judge, he used to be, I'll come to little detail, but firstly I'm giving you overview. So reference judges have a crucial role. Similarly, role of the advocate is of profound importance, because they, being a very important stakeholder, have to make a crucial impact on the growth of mediation in India, on this strengthening the culture of India, uh, and to make it a primary mode of dispute settlement. Uh, so now firstly, I will give you the role, advocate's role. You see, advocate's role in mediation is fundamentally different than the litigation. Question is how it is different. Because what a lawyer advocate is supposed to do. You see, his role is that if client has come, client wants relief, speedy disposal of his dispute, resolution of his conflict. So he wants relief, and he wants with speed solution to his problem. And the role of advocate is that he has to be fair in the traditional setting. He has to ensure that the hearing is fair to both, to his client. The trial is fair. He has to ensure, and then he has to, by coming to the fore, he provides peace of mind to the party. Cost, then he has to see the cost. Then a lot of things. Then after the case is settled, is to see that matter is executed. The decree is of no use unless it is executed, unless a party gets the fruit of the decree. That was the traditional setting. But here in mediation, also his role, her role is proactive role. He has to play proactive role. Therefore, lawyer advocate should know what is mediation, what are its benefit, what role he has to play. And one of the you see important role I see is when advocate accompanies the party in the mediation, then he also becomes he's part of that conflict resolution. Because in mediation we say we have to attack the problem, not the person. In traditional setting, parties at the council is at the forefront. Here, parties at the forefront. Of course, council role is very important. Now, when parties now suppose there is a deadlock, party is not understanding, because in separate session you will know what is done in separate session. Once in joint session, issues have been identified. Parties have understood what is the case of each of them. Mediator has understood what is the case of each of the party. Then, before options are generated, parties are adamant. There's a deadlock. There's a stalemate. Then the question of comes of reality testing. In separate session, which we call often we have the brainstorming session, where we mediator will discuss with the party as to where party stands on facts, on law. Then the role of the advocate as an advisor, what is the legal position? Because a party may not know, party doesn't know the law, may not know the law, or the implications of the law. Lawyer knows that where parties stand. His role is to advise the party that, look, this is a legal position. This is the judgment. This is a legal position. You can't have that. And you will come across when you will read, if you have a one of the, I think, paper or semester or a chapter you have, I exactly do not know. Uh, is it one full semester or one paper in mediation you have? Anyone?
So we have a specialization of mediation.
All right. So there you will see that when you will see what is the best alternative to the negotiated agreement, Blatna, which we will see. Best alternative, worst alternative, one is most likely alternative. Then in arriving at the most likely alternative, council's advocate, it is his duty, it is his important role to make his party understand, look, here you stand. And then time, time factor, uncertainty, money, of course, money factor, party will understand. But uncertainty, if a party suppose wins after 5 years or doesn't win, party may not know. There is uncertainty. But here would be certainty that it is he's getting. Suppose after 5 years he's getting rupees 100 and now he's getting suppose 70. There is a certainty. And that 70 is invested after 5 years or with whatever, if he invest in a prudent way, all those things have to be worked out during those brain related testing. So here, role of the council is very important. So we say his role is at all the stages, like judge at pre-mediation stage, during mediation, and the post-mediation. All three stages, advocate and judges have the role to play. So his role is continuous. Whether dispute is, if dispute is usually not settled, he'll again continue with the litigation. If it is settled, now pre-mediation stage, he will advise the party. Because now you see, in coming time, when we have this pre-interest mediation, then there would also be pre-conferences preparation, where advocate, even when suppose a client comes before the advocate, even at that stage, advocate it would be his duty to, because his settlement is becoming the policy of law now. And legislature, executive, everybody is now promoting area. And it has come to stay, having regard to speed, having regard to its intrinsic worth. Therefore, council would advise a party, look, there exists this ADR mechanism, mediation, which you can take resort to. So it will be the duty, it is the duty of advocate to guide him, to educate him, to make him aware about this concept of mediation. Party may not know. Concept of mediation, advantage of mediation. And then during or other, before that, before mediation or during mediation, to convince, to persuade the party, to make him understand ki why or why not this mediation before litigation should be taken recourse to. So this is a very important role of the party. And also it make him understand, make her understand that relationships are restored and there are creative solutions which may not be there. Of course, time and uncertainty is one factor. He will make him understand that it is a win-win situation, that he has to figure out that these are the options. All those things will have to be clarified to the party. Now, during mediation, the party must be informed about what are his strengths and the weaknesses. That, as I said, brainstorming session or all these uh, restoring relationship, restoring restorative justice, that SWOT analysis, where he stands. Because we have to see his role can be constructive, it can be destructive if he doesn't do his duty. Because if party is not guided properly at the proper time, and then parties suffer. Of course, as far as fees question, sometimes council, some parties say that the fees would be affected adversely and all that. I don't think that in the long run, once because now this mediator, private service, mediation service provider will come, once with your skills, because earlier, of course, argumentative skills was being given importance, but now this soft skill, your settlement skills will have to be given importance. And with your, once you build your capacities, once you have those skills, advanced skills, and build your credibility, then of course people will say, look, this lawyer mediator, and then it will become a special branch, you see. You may not have the even the litigation. You may say, I'm a mediator. And then people will say, look, Miss X, Mr. X is a mediator where I should go. That time, you see, is coming, will come, it has come to stay. You have to take it. So, uh, whenever there was reluctance, as a judge, I used to see many cases when I would refer cases to the for the mediation. Some of the counsel would say, no, I don't want mediation. Then I'll say, okay, tell me you don't want mediation. You know what is mediation? Okay, no. He say, I know. Okay, he know. But why not mediation? Tell me, give me one good reason. Now, suppose I have framed issues in a case. It is a commercial case, for example. I have framed issue. Now, a date of 2-3 months is being given for plaintiff's evidence. Now, there is a gap of 2-3 months. Now, this 2-3 months time, why it should not be utilized for mediation? You are not losing, client is not losing anything in terms of time, energy. It is free of cost there. Of course, here when it becomes private, fees will have to be paid to the mediator or mediation service providers, etc. So same way, here cost fees is being paid to the advocate also, apart from other expenses which parties have to incur. And here one of the advantage also which as a lawyer you can tell is that court fees is refunded as per law. Once it is settled with the assistance of mediator, so all these things have to be. Then during mediation, as a lawyer, mediator will tell them these are the ground rules. Because mediator has to control the process. Mediator cannot control the outcome. You see, he will not control what will be the result. Like a judge, he will not be because he is not deciding. Self determination is there. Parties are deciding their case of themselves. So, but process he has to control. He has to that maintain decorum. He has to see that parties do not blame each other. Parties attack the problem. Parties understand perception of each other during that process. So ground rules. As a he has to make parties aware about the ground rules. In ground rule, what we say, ground will say, look how they have to maintain, how they have to behave in the mediation process. They are not to attack each other verbally or of course otherwise. And then one party will speak at a time. Because the idea is when mediator enters into the conflict, he changes the paradigm. He changes the dynamics of the conflict with his calmness, with his skills, with his empathy. Of course, he will not sympathize with one or the other party, but he will have, he hear the parties, you will see active listening, empathy with empathy. What happens? He then changes the direction of the conflict. Where parties were moving towards the conflict, they start moving towards the solution. That is what his goal is. Then he opens, keeps the channel of communication open because sometimes deadlock is there. Then he uses various techniques like summarizes. He, as I say, he detoxifies the inflammatory language used by the party. But I said detoxify, takes out that inflammatory part, abusive part. Only he paraphrases, summarizes. If a party is giving a long thing, so for example, in the matrimonial matter, parties have long stories, long things to tell, then he will ask close questions. If a party is not opening up, he'll ask open questions. So you'll see there are a lot of, we see it is a structure, it is a art and science. Science, it has several techniques which you will learn when you will take techniques of 40 hours training before you become mediator. So those techniques changes the dynamics of the conflict. So that ground rules. So as a counsel, as an advocate, his duty is to ensure the ground rules are observed. Then he must encourage the party. That party is present. Many cases we have seen that court will refer a case to the mediation, one of the party will not appear. He has to impress upon the party, encourage upon the party. Look, this is for your benefit. You have to appear. He has to appear, find time to appear along with the party because he has to perform his proactive role. He has to act as a catalyst. Of course, mediator is also a catalyst, but advocate is also a catalyst. Uh, so he must tell the address the party about the flexible position that he should not adhere to a very adamant position. He should be flexible, having regard to the time, the uncertainty, and the money. That flexibility. And regarding option generation, and having regard to as a council, you have to also to keep in mind that parties have actually three types of needs. He has to understand what are the needs of the parties, what are his fears. Three types of needs you'll see. One is procedural need, other is psychological need, third is substantive need. In every country, procedural needs because party thinks that it should be fair and all that. That when a party goes to the court or party for the mediator, parties expect that fairness that we know is a part of our system, principle of natural justice and all that. In all, need arbitrator, need judge, those things are very basic. So, uh, Then psychological needs, that parties think psychologically it's a safe environment. And substantive needs. He has to be very clear. Substantive is what is the dispute all about, what are the facts, and what is the legal position, etc. So as a counsel, he is supposed to be well versed. He has to be master of fact, master of his party's case, master of what are his expectation. But he has also to make his expectation realistic, because they at times will see mediator of course has to assist that in making realistic, but counsel would see that his expectation of a party is unrealistic. It can't be achieved. So he has to make them realistic. And during that sub caucus or caucus session, his duty is to assist the party, and even separately before that. Then cooperation. Then his role would come in recording settlement. Once parties settle, once parties settle, they have to record settlement. Then he has to see that settlement is specific, it is realistic, it is time bound, that it is as per law. All those things, it is a role of the advocate also. Because if lawyer, he cannot be ignorant, can't be passive at that stage. He has to be play a very active role at that stage. So now, if I sum up the role, so what does it offers? It offers him, you see, a stable fees, a satisfaction of his client, his own satisfaction, when parties settle, when there is expeditious disposal or solution of the dispute, it avoids adjudicatory process. Of course, once it is not settled, of course, the option of arbitration and litigation is open, and the less hassle is there, and that faith, restoration of the faith of the people, which at times he says being eroded because of delay, etc., that is being established. So he is a stakeholder in the legal system. So it is his duty to establish that faith, re-establish that faith which is being eroded. And we see that more and more cases will come to the mediation in that way. And you will see that this mediation will become a remunerative with passage of time. You will see. To take my word, it is bound to become more remunerative for the lawyers. And even that 10 years standing which we have, I think that also with passage of time, uh, my intuition is might be liberalized when we say that mediator would be coming from other fields of not only lawyers but from other field experts will come. Recently, we imparted training to the apart from DRT judges, those CMD, the MDs of the banks, because those they have technical knowledge, because they are assisting settlement of the bank's cases, NPA cases, a lot of other cases, recovery cases. So specialized, you will see specialized mediator will come. There may be specialized mediator in the field of negligence, in medical negligence, in contract cases, in matrimonial cases. That time is coming very soon. That is my uh, understanding. So specialized branch will come, and we have to, as a lawyer, we have to focus on those soft skills, deal making skills, expert in negotiation skills. Then we see now at present arbitration clauses are there in the contract. Now you will see mediation clauses in the agreement or mediation clauses before arbitration or litigation. Even I was seeing there was a one office memorandum of Ministry of Finance in that regard, where they have requested the PSUs and the government functionaries to take recourse to mediation. And of course, then this training and development of special skill has to be emphasized. Capacity building has to be a continuous effort, like now in school, colleges, universities, that that will become the basis, because in bringing awareness from that very level, only then I think we will be able to strengthen that culture, as we say, culture of mediation in India. And now I'll briefly touch up the role of the judges. As we say, their role is also at three stages very important, because earlier you see in the adversarial legal system, emphasis on litigation. Now, because expectation of the people is they want speedy justice, inquisitorial, participative. Even as a judge, we used to say judge can't be a referee. He can't be like an umpire that look, he's sitting, advocates are arguing, or they are controlling the process. No, I practically, during my experience, I never thought like that. I always played active role. And I always impress upon my other colleagues and junior colleagues that look, as a trial judge, your role is to find truth. So you can't be active, you can't be passive spectator, like a referee is right, is wrong, to decide one way or the other. But right from the day one, when the new case comes, you have to be very active. You have to understand the same way what is the dispute, whether it can be settled, whether you have taken recourse to mediation. If not, why not? Because now the question is not why mediation, question is why not mediation? Or why not one of the area? But in other area, we see again arbitration. We see is also like a private judge. There also it become time consuming because of you see, although theoretically finality is there in those provisions, section 535, but you know those challenges, section 34 and 37, you see, lot of taking lot of years, and people are now finding that again it is not serving their purpose. But mediation is proving to be more satisfactory, more quick, more flexible process. Therefore, that is why now, even before arbitration, mediation is being emphasized, harped upon. Uh, so now in 21st century, we need effective and multi-door dispute resolution system. Uh, there, in the context of the court, if I say Voltaire, he said, I was ruined twice in my life. Once when I lost the lawsuit, and once when I won the lawsuit. And we used to say that the quarrel battle of the litigant starts after decrees passed in his favor. Because execution of decree is again that much difficult. So much, so many obstacles are there. That is why now, along with the speed and coupled with the intrinsic worth, as I say, we are giving importance to this. And wrote already I have referred about AFCON's judgment, where you must read that AFCON judgment. Some of those who have not read it, AFCON's infrastructure versus Cherry and Berkey Construction Private Limited, 2010 Supreme Court. You please read it. It gives it a very detailed judgment, gives detail. So in the traditional system, I was talking about the role. There we have, as a referral judge, when the case is referred to the mediation center, court next mediation center, then referral judge persuades the party. His role is to encourage and to persuade the party that look, whatever reluctance a counsel or party has, he will, she will make them understand, look, it is for their benefit. This is a mediation. And I tell you, I have done this in hundred of cases during my tenure as judge for 32 years. More than 32 years I served as judge. And in hundreds of cases, I persuaded parties. And they, who were elected initially, and later on they found that it was settled. But of course, your power, be judge or any authority, power is useless if you are not able to persuade the parties who are before. So as a full-time coordinator, what he does as far as because here we have judge mediator in charge of the mediation center. We have in district courts or in high courts we have advocates who are manning those in Delhi High Court Samadhan. In Supreme Court also we have one registrar, I think, doing coordinator. So their mediators are empaneled. Mediators who have put in 10 year of practice and who have got that training, they are in panel. The cases are then assigned to the mediator. They'll decide. He will assign coordinator, judge in charge will assign the case to the mediator. And then, of course, he will have supervision, progress of the case. He will ensure that that time limit of 2 months plus 1 month, which rule provide, is done. Then he'll submit report to the reference judge. He'll take feedback from the participants and will take corrective measures about the process. He, as a reference judge, you see, he will also bring awareness to the party. Now, often we had seen, we were asking our staff to attach those pamphlets, handbills, along with the summons, notices sent to the parties. Because party, general public has to become aware. And we had seen general public at times were not aware. Still that awareness, we have to work upon that. So that general public is aware. And that is one method, cases filed. Of course, lawyer will do at the pre-litigation stage. Judge will do when the case is filed. He will attach that handbill so that when the party receives a summon, he knows what is mediation, so that he can take recourse to that method at the earliest, at the first stage, or if not at the first stage, at the stage of framing of the issue, when there's a time gap. So that awareness, of course, he has to bring that. I think all the stakeholders have to bring uh, in in whatever way we can do. Uh, that is one. As far as then certain incentives are being given to the judges, so that when I told you refund of court fees to the parties, that is for the party. Then you have some unit system in the district courts that if the case is settled, then the judge gets some incentive for that. Otherwise, you see, one might think that why I'll spend time on this. Same the way lawyer think why I'll not get fees in that. Why should I spend time? So some incentive is being given. So, and one more thing, as a referral judge, his role is, so he can say when the case is being referred to the mediation center, look, if a party will not appear before the referral center, some cost might be imposed. I used to say, because we had seen many parties are not appearing initially. I'm telling you about 10 years ago. Then I used to impose cost upon the party. If without any justifiable reason, party will not appear. Now you have wasted 2 months' time. Why you have not appeared? Some cost, court can impose cost upon the party for non-compliance, for non-attending or failure on its part. So awareness building is one thing. And then after post-mediation role of the judge is that once parties come, of course, when parties come with the non non-settlement one report that matter is not settled, then of course he or she cannot ask that why it was. He can, of course, will not go into details what party said what, but he can just assist the parties. Even after settlement, you will see sometime one of the party will try to wriggle out of the settlement. Parties have signed the settlement, but now in the court, when parties have come, it is being sent with the settlement. One party say, no, this, that referral just can say you can't do that. And even there are certain judgments on this, that a party cannot be allowed to wriggle out of the settlement. Once they have settled, they have signed the settlement, council have signed the settlement, why it should not be enforced? Of course, if party shows something, some serious thing, some fraud, etc., then judge has to decide. If you read Order 23, Rule 3 proviso, you'll see that judge has to decide that then and there. and adjournment of not more than 7 days to be given for that purpose. He can't say, okay, come after 2 months, 3 months. Parties have settled. Now it should go out of the just the system. That is the whole idea. Uh, Reduction of the case, areas of the cases, and win-win situation. Of course, rules. He has to ensure that those mediation rules which are there are complied with. So at all stages, and someday you'll see when settlement, he can remove the difficulty. There might be, you'll see there are certain defects in the settlement recorded by the mediator, certain gaps are left. Then he can fill that. He should fill that gap. That is his role. So broadly, I think, outlined the role of advocate and judges. So as society and legal landscape evolves, importance of mediator as a institution or even as an ad hoc mediator and the role will change. It will become important. So we'll see his role of the advocate and judge is very vital to strengthen this success and bringing about the culture of mediation. This is what in this opening session I have to say. Rest, I think now we can interact.
Thank you so much, sir, for such an enlightening session and for sharing rich experiences and factual knowledge about mediation. Now, I would like Deekshika ma'am to take the charge of session.
Good afternoon, sir. Sir, I think you have to switch off your mic for some time. Otherwise, there will be. Okay. Sir, thank you so much. It's still echoing actually. Sir, can you please switch off your mic for 2 seconds? We are checking.
Volume is little less. I think I'm not able to fully get that. Yeah.
Sir, can you switch off your mic for few seconds? Okay. Am I audible now? Okay, thank you so much. Thank you so much, sir, for this wonderful session. Actually, at the start of the session, we have 8 questions on this topic role of judges. And I was listening to the session, all 8 questions have already been answered by you. So it's a wonderful and insightful session. Thank you so much again, sir. We are actually honored to have you on our online platform, and students are gaining the actual practical knowledge about these sessions. Thank you, sir, and we are looking forward for further sessions. Sir, you can open your mic now. It's all good now.
Thank you. Thank you very much.
Thank you, sir. On
Yeah,
this
but I
note-
would desire if all the participants have their audio, video also on.
And
So
we
I
will.
generally, my method, I like, I think with interaction, we learn more. I think,
Yes.
yeah, of course, one-sided lecture is good, but interaction
No, no.
is, I think, that is a way when we have more curiosity.